Good afternoon, everyone, and welcome on behalf of Trust Mediation to this lunchtime webinar. I would like to begin by introducing you to our special guest today, Professor Sue Prince. Sue is a Professor Emeritus of University of Exeter. She is a CEDA-trained civil, commercial and workplace mediator, and also a community mediator for Devon Mediation. Sue recently taught a master's module on law tech, AI and the future of law. Sue is a member of the Civil Justice Council and has led empirical studies researched and written on court-based and mandatory mediation and co-chaired initiatives on digital inclusion in the justice system. You will see that we are recording, and the recording will be available shortly after today on our website. You will also see on the screen a disclaimer, more necessary in this kind of subject than mostly. But please note we'll be giving our personal views and not advice that should be relied upon, particularly when trying out new AI tools. The areas that we shall be covering, if I move on to the next slide, just to refresh your memory, that's what we'll be covering today. And you should have on your screen a Q&A button. Please do not hesitate to use that to put in questions if you'd like to do so. We will have a Q&A session at the end. So welcome again. The usual cross-section of claimant and defendant solicitors, people from the medical defence side of the business, and also following Trust Mediation's recent course at Reading University, a number of students from Reading University. Welcome all, and let's get underway. Sue, the floor is yours.
Thanks so much, Tim, and thanks so much for inviting me along today to discuss this really interesting topic. I wanted to start off by saying something about the speech by the Master of the Rolls, which took place at the end of last week, so hot off the press. Sir Geoffrey Voss, who is the current Master of the Rolls, gave the keynote at the Association of Law Teachers Conference at my own university, at the University of Exeter, and I thought it was a good basis for discussion because it certainly roused a lot of interest at the conference, and so this is hot off the press. So I've put in a few bullet points there, which I think adds my interpretation of the speech. You can find the speech itself on the judiciary website. If you look at the title there, Lawyers and Legal Education in the Machine Age. Essentially what Sir Geoffrey Voss was saying is that there's a need to prepare the next generation of lawyers for what lies ahead. So I was interested, Tim, in what you said, that we may have some students on the call, because I'd be very interested to hear what they think about what I'm about to say. The Master of the Rolls said that lawyers will be needed as much in the future, if not more so in the machine age. So it's not that there won't be the end of careers for lawyers, or as Richard Susskind said, it's the end of lawyers. It's that the world is changing and that what we need to do is to get on board. So the legal system is at a turning point due to the development of AI and emerging technologies. And I'll say something about emerging technologies shortly. Voss argued that we're entering a machine age where artificial intelligence will significantly reshape how justice is delivered, making change inevitable, and that we need to keep abreast of that change. So part of that is that AI will increasingly handle routine legal decisions. And he predicted that many routine judicial decisions will be made or guided by AI or by machines because they are faster and cheaper and may become widely accepted over time. And I suppose if we think about the current state of our courts at the moment and some of the issues that have arisen in terms of delays and efficiency, that looking towards AI will become increasingly something that administrators will wish to do. So it'll be enticing to think that AI can do some of these tasks that we need it to do. Alongside that, Voss was saying that lawyers will remain essential, but that their roles will change. So rather than disappearing or that AI takes over the role of lawyers, he was suggesting that lawyers will shift towards interpreting, explaining and guiding clients through AI-generated outcomes and complex legal issues. So a shift in the role, and also, as we can see by looking at some of the advertisements currently for legal roles, that there's a shift in the types of roles that are needed for lawyers to undertake. So we might want to think about some of that. Additionally, client expectations and behaviour are being transformed. So clients will expect faster and cheaper services, and lawyers must transform in order to be able to do that. There's a fundamental shift in how legal problems are managed. So in February, the Master of the Rolls, in a previous speech, so just a couple of months ago, said that AI is now being used by almost every litigant in person and small business. The first port of call used to be a lawyer if one was available and affordable. Now the first port of call for all court users, is ChatGPT or Copilot. So that's something that the Master of the Rolls said a couple of months ago. So building upon that, in this speech last week, he said that clients will expect faster and cheaper services, and that lawyers have to be able to react to that. That legal education itself, as a reaction to some of what he's already been said, needs to be fundamentally rethought. We need to really think about what it is that students need to know in this machine age, and how the processes of law are going to be examined by students. So critical skills will be very much needed, but then we also need to be thinking about how we're going to be using AI and technology. So maybe there's other things that lawyers also need to do that they haven't needed to think about before. And the key skill of future lawyers is explaining complexity in an AI world. So as legal information becomes widely accessible through AI, lawyers will be valued less for access to knowledge. So just knowing things isn't going to be necessary, because we're going to have these tools that can do that, but more for their ability to interpret, contextualize, and explain the law. And he was saying that, senior judges, I suppose, like the Master of the Rolls, will always be needed, because there will always be a requirement for appeal against machine decisions. So at the very top of the tree, there will be a role for senior judges. So that's something maybe we should all be aspiring towards, if we want to guarantee a future role in the MR's world. I wanted to sort of build upon some of that by just looking at a few AI issues just to raise for discussion before I pass over to Tim. So Tim, could we move on to the next slide? Yeah, so just a few AI and technology issues that I just wanted to expand upon briefly. First of all, the growing use of generative AI tools and technologies. So when we talk about AI these days, and especially in the context of the sort of AI that lawyers are using, mostly we're talking about generative AI, and that's sort of where we are at the moment. But tools are developing incredibly quickly. And so that's something that we'll need to think about. So first of all, it's sort of thinking about, how do we define AI? What is it that we're talking about? And also, I think understanding that when we talk about AI, the person we're talking to might have something different in their head, because they might use it in a slightly different way, or in different thinking about different iterations. So alongside that is the idea that AI and AI tools are developing phenomenally quickly. So as Tim referred to in his in my introduction, he said that I have taught for the last couple of years a master's module on AI, law tech and the future of law. And one of the things that's happened during that module is, even starting teaching it in September, some of the issues that we're talking about by the time we get to December are new. So the world is changing so fast that we need to bear that in mind when we're trying to contemplate some of these ideas. Also, the other point is that the potential use of AI is extensive. So Thomson Reuters have said that the proportion of lawyers using generative AI increased from 14% in 2024 to 26% in 2025. So we think now we're in 2026, that is obviously going to increase even more, since that data was put together. So just to bear those things in mind, that lawyers are using generative AI, and what we need to think is how we use it appropriately and properly. Also, the increasing number of clients using generative AI. So I alluded to a bit of that in what I said about the Master of the Rolls, but I think what drives lawyers is what their clients are wanting, obviously. So if clients are using generative AI, then lawyers need to be able to respond to that, and they need to be able to respond to what clients are asking for. And we know apocryphally that there are now clients who are doing a lot of the work themselves and then going along to their lawyers and saying, now can you check this, because I've produced my own contracts and I'd just like you to look through it. We don't need you to do some of the things you were doing in the past. So the behaviour of clients drives the work of lawyers. Additionally, there are new types of technologies like Garfield AI, which is an AI piece of software that assists with small claims by generating letters itself, drafting and submitting claim forms, also submitting the forms, applying for a default judgment in the court, and basically doing all the work for you for a very small fee. So there are these new tools emerging that are also going to be a threat potentially to lawyers. There's a need for lawyers to understand the limitations and ethics of AI. So the cases that are coming up before the court quite rapidly, like the case of Ainde and London Borough of Haringey, show the implications for the administration of justice if lawyers do not use generative AI responsibly, because we know that AI has a tendency to hallucinate cases, and so there needs to be always a lawyer somewhere in the loop checking that the work of the technology. So that's just something to bear in mind, that in order for lawyers to use AI, they need to really understand what it can do and to be trained on AI itself. The pressures on the court drives greater reliance on technology. So there's a development of the digital justice system is underway at the moment, and the needs of users is going to be important there. So the more we rely on technology, the more we need to think about the inclusive nature of what we're devising in the court, and the fact that some people just don't have access to technology. So alongside our need to understand technology and understand what it can do, we also need to bear in mind that there are people who just will not be able to use it for a variety of reasons, and that we need to build that into our thinking about the development and design of the justice system. And then the final point I just wanted to make in this sort of quick scoot through AI technology issues that I've raised today is that professional regulation and rules are still evolving. So traditionally, the law has been built on being reactive, that we apply rules and precedents to issues that arise before the courts and before ourselves on what has happened. But with technology, we maybe need to think about how we can be more proactive because of the fact that technology is moving so fast. So firms need to think about an AI policy if they're bringing in AI. They need to watch developments, have rules and guidance, and to be thinking about proactively about the ways of working. So once again, this raises new ways for lawyers to be thinking about how they're going to be tackling the future of law and the legal system and the legal profession. So there's a few openers, Tim, just to sort of get us going.
So thanks very much indeed, and I'll come to my parts now, and do feel free to chip in as we go. Now, for my part, this is not a polished presentation or an expert or a comprehensive view. It's more a chat about a number of snapshots, the result of me following the development of AI, viewed through the prism of the PI and ClinNeg sector and what it means for the sector. So let's pick up on some of the themes that Sue has mentioned on current and emerging uses. There is a lot of going on regarding automation of workflow, the back office and the admin side, MS Copilot and so Microsoft Copilot and so forth. But I don't propose to discuss those today. What I want to focus on is the emergence of AI into the negotiation space and the mediation room. And for the lawyers that are out there, and I hear this from time to time, well, that's not for me, I'm going to carry on as I was. That's not really a choice that you have, I would suggest, and Sue has already alluded to this. You may be working in one way, but the opposing lawyer or lawyers may be using AI, your clients may be using it, and so you need to react to that. So I think that's an important point to bear in mind, because we have now, I think it is clear, crossed the watershed of speculating about AI coming into negotiation and therefore litigation and mediation. It's happening now. And that was made clear to me by a LinkedIn post that I saw within the last week from a friend and a fellow mediator, Julia Burns, who recounted a mediation she was involved in, and when she went back into the mediation room partway through the day, the client and the lawyers were held around the screen looking at what AI was saying about their next move. And that was her introduction to AI being in the room for the first time. Now, there are various issues on ethics and so forth, confidentiality, which we'll come to. And one is, to what extent should your use of AI be disclosed, or when should it not be disclosed? Sue has already touched on the use of AI by litigants in person, and the MR has referred to a potential surge of AI-assisted litigant in-person claims. And I've had a number of anecdotes given to me by practitioners about how they're seeing more of these claims, and what would have been a 1 or 2 paragraph letter is now a 20 paragraph letter with authorities cited and so forth. And the source of that more sophisticated approach is clear. And this gives rise to what I call the LIP dilemma. What is an LIP plus an LLM? Well, it's somebody who's got, as an LIP, got a lot of reassurance and some of the fog being lifted by the helpful explanations they can get. But one of the key problems, as I see it, is that they don't have the knowledge, for obvious reasons, to be able to assess the output that they get from the LLM. And I think that is going to present a problem to practitioners and to the courts. The other emerging use I should be touching on is what is happening with the plaintiff, good old-fashioned word, the plaintiff PI law firms in the States. And they are motoring in this area with huge amounts of money being invested. We'll come on to that. There is also, to mention, next level mediation. That's the URL of that website I'll be giving shortly. And this is something which has been happening, which has started to happen really before AI really emerged, and that was the application of decision science tools to negotiation. And that is still going on, and AI has facilitated that, and I think we shall see quite a lot more of that. So negotiation is going to change, I think. So anything you want to add on emerging uses that we've not covered?
Just one point that the Master of the Rolls made last week, which is sort of the corollary to what you were saying about LLPs in terms of not knowing about the use of the law. I think he was saying that some judges have found that actually there is more sophistication in some of the paperwork being used by LIPs because of the fact that they're able to get the assistance of AI. So I suppose as AI becomes more sophisticated, you might have some claims that are coming through that are spurious because of the use of AI. But on the other hand, you may find that it does help some litigants to actually be able to put their claim together better than they were able to do on their own. So, you know, we don't really know what the impact of it's going to be, except that there will be an impact.
Indeed, thank you. Let's move on to this question, which has been talked about by mediators. You might also say negotiators as well, so that brings it home to a lot more people. One article I read referred to an American a knowledgeable commentator whose view was that AI is not yet able to navigate complex emotional and human disputes. And that kind of comment makes mediators relax a little. And John Sturrock, a Scottish mediator, wrote on the subject, and he started off with what he found a commonly held view that law is fundamentally people-focused, and technology should enhance rather than replace human judgment. So that's so far reassuring. But as John Sturrock went on with his research, he said that he was very attracted to an article, one of the sources commented that in fact AI was developing rather more quickly than that. And that commentator said it's like the moment you realise the water has been rising around you and is now at your chest. So differing views on that. There are in fact already bot mediators, and mediator.ai and botmediation.com are particular examples, as is the mediator.ai. And I've looked at a couple of these systems already. Some research carried out by the mediator.ai found that in relation to negotiations, that human aligned behaviours emerge when these LLMs are trained on diverse negotiation scenarios. So we may have views on what AI will and will not be able to do in the future, but those views may or may not be correct, and there's some people who say that they're not. Getting into rather scarier territory of facial recognition, there is some software you see there called Crystal Nose emotion recognition. And talking on a screen like this, if you're in a meeting with someone, you can apparently, I've not looked into this, but I've heard about it, you can use the software to predict the personality of the person on the screen in front of you. That will give you a readout, and it will give you tips on how to deal with, how to question that person. And I've quoted it there in quotes because it's used in sales, so you can build stronger relationships faster and win more business. I find that is a little on the scary side, but certainly that is the kind of thing which surely must be disclosed before it is used. The use of that without consent, I think, would be abhorrent to most lawyers. Have you come across any thoughts on that? So anything about whether is AI going to replace negotiators, mediators, lawyers?
I mean, I think we have had technology systems for quite a while that can negotiate sort of blind bidding type programs where parties can each put in a number and the technology suggests whether they're close to each other but without revealing what the amount that each party's put in. So sort of even fairly unsophisticated negotiation software has been available for a while. I suppose on the other side of it as well, thinking about, there's a growing need for more mediation, and we can see that with the small claims mediation that the courts are currently running. And I think there will be more need for mediators in the future. And I also wonder about whether AI could be a really great training tool in order to create sort of simulated mediation scenarios, which will help train future mediators in a way that really involves them in the process and can do various different things, stop along the way, ask for feedback, etc., etc. So there may be some really good sort of training materials that AI could help us to develop in the future.
Thank you, Sue. So what about practical use? And I'm coming here really right down to the personal injury and clinical negligence area. In terms of AI having crossed into this area now, I'm referring to an article there which is mentioned by American academic Amy Schmitz, and she wrote on this subject. And a couple of things that she said is this. AI is already reshaping how parties and mediators prepare for disputes, how mediators manage complexity, and how parties experience the process itself. AI's greatest potential in mediation is as a coach and preparation partner, not as a decision maker or substitute for professional judgment. And another commentator who provides software for ADR case management, this is ADR Notable, their approach is that all the AI-enabled tools that they supply are designed to be visible, optional, and subordinate to professional judgment, supporting what mediators have to do. And there's plenty of evidence now that these tools are actively in use, and one which has been known about for a little while for those who follow this subject is Professor John Landay's RPS coach, Real Practice Systems coach. Professor Landay, I mentioned him in previous webinars. He and a number of other American academics developed real practice systems. They've done a lot of academic work reviewing negotiation and mediation. And Landay put his work onto a private GPT, which has been designed to assist parties and lawyers and mediators as a coach. And I'll come and say a little bit more about this at the moment. Just yesterday, I think, or the day before, I saw in Legal Futures that a lawyer has prepared a new tool, an AI adversary, to dismantle legal arguments. And the idea here is that when you're going to court, you've got a submission to make, you're going to a mediation, you want to run an argument, that you can put this to this software, which will act as your adversary in attacking your argument. And in doing so, you learn you can strengthen it. The suggestion is that if you do that with the lawyer in the next room, they may be a friend of yours and not disposed to be really as blunt as they might be, but the machine will tell you how it is, warts and all. Really kind of fascinating. We're getting secondary tools, not only how AI might help one party, but how it may oppose another. Moving on and saying a bit more about John Landy. This is a little about what his negotiation and mediation coach does and does not do. I have experimented with this quite a bit. I've used it in preparation for training and for talks and so forth, and I have been quite amazed by what it does. That's not an overall recommendation. All of these AI tools need handling with great care, but I think the work that Landy has done is certainly impressive. Thinking of the work in the sector, I put some questions to the coach about what it could do in a claim, personal injury or a clinical negligence claim, with a party who was preparing for a joint settlement meeting or a mediation, and saying, well, can you help on these things? The answer there in the blue box is certainly, and there is a description there of the help that was given, and also the disclaimer as what it is not. And there then followed, as I went through, and we don't have the time, and it's difficult on this side of the screen to show you the examples that were given, but they ran to 10 pages, including some very detailed approaches to analysis and so forth. So I invite you to play with that tool yourself, and you'll see a little bit of how it works. And I think you'll start to get the view that these tools, or many of these tools, are not to replace what we do, but to assist and augment and to challenge us. And certainly I have found them very stimulating, and I use this tool quite a lot now. Another example I ran today was on an LIP, and I said, look, coach, I'm a litigant in person in the English County Court. I'm autistic and I have problems with hearing. What can I expect of the court in terms of helping me out on these problems? And I got a very good but rather woolly answer, but helpful nevertheless. I then pushed a bit further and said, yes, coach, but if the court doesn't really look very helpful on these things, what are my rights? What can I do? And I then got a very detailed exposition of the Equality Act, of the Equal Treatment Bench Book, of the CPR, and an offer from the coach to write a letter to the court. Coach said, just tell me a little bit more about the problems and what the court has said, and I will draft a letter for you. The kind of sophistication, I think, that Sue was talking about, because, of course, if a court has got to deal with a vulnerable person needing reasonable adjustments, they need the information. And that's an example, I think, of where this tool could provide that kind of thing in a way which is of assistance to all concerned. So I agree with Sue. There may be some pluses on the use by LIPs as well as the minuses. Confidentiality, ethics, and data protection. This is a big area, as Sue has said. These tools are being developed on a daily basis, and they're running way ahead of regulation, which puts a heavy duty on us, a heavy responsibility on us as professionals when we're working in this area. The headline there, again, there's nothing sophisticated in that. That's the kind of mantra that I've developed as I'm working with these tools about how to approach things. And in particular, I think we're all aware as lawyers that confidential client information should not go into a general LLM, which is being used to train elsewhere, although I have heard some horror stories about that. And I've heard of American attorneys and mediators using LLMs, private LLMs, on the basis that they put a anonymized scenario into the LLM, and seek options, to generate options in a mediation as to which way they may go. So that is a way of dealing with client confidentiality. I've also come across some software called the Anomalizer, which has been fairly newly developed by the author of Next Level Mediation. And essentially what this does, and I'll demonstrate this in a moment, is to take a document, and this is software on your own machine, so it's not in the cloud or anywhere. So you can put your client, your confidential document into the software, and it will then anonymize it. And I'll say a little bit more about how that works in a moment. But if you're in a very large firm that has its own private LLM and can accommodate client information on a proper and secure basis, that's one thing. But if you're a smaller organisation where you don't have access to that kind of approach, this might be a way of you using AI and dealing with the confidentiality, the privacy point, which of course is so important to us. I mentioned there Colm Brannigan, who's written about disclosure and confidentiality, and this is the point I raised before about if you're using, for example, Crystal Knows, or you're using any kind of software during the course of a negotiation, what duty do you have to the mediator, to the court, to the other party, to disclose that? And that is a live subject, I think, where there are no black and white answers, but is a good area for professional discussion. I should also mention, just by way of passing, that there is a Civil Justice Council AI consultation ongoing at the moment. It may have closed or about to close. Sue, can you say any more about that? I know you are a member of the CJC.
Yeah, I'm actually sitting on that working group for that consultation. I think it closed at the end of last week. I think the consultation is really about whether there needs to be a disclaimer which is put on the front of all court documents so that the court knows exactly whether someone has used AI and is able to know who is accountable, so that there's a lawyer who is responsible for the work before the paperwork goes to court. And it's really, I suppose, encouraging lawyers to think a bit more about how they're using AI and to raise some of those issues, because if you're going to have to make that statement, you're also going to need to reflect a bit on your role and what you've actually done. So I think it's bringing a lot of those sorts of issues to the fore, although, you know, the use of AI is just going to become ubiquitous in the future. So this is sort of a starting point, but I think it does raise a lot of those ethical and professional issues of professional responsibility for lawyers. So there will be other bodies, I'm sure, coming in with similar ideas and thoughts about how lawyers should be using AI into the future. But yes, it's a really exciting, I think, consultation, and sort of watch this space as to what happens next.
Thanks, Sue. And I think that's what you said there goes back to the danger facing lawyers when there is a black box type of AI, because if you don't know what the machine has done and you can't stand behind its output, then you shouldn't be using it. And if you are, and something goes wrong, then you are going to be accountable. And the fact that, well, the machine came up with the answer and I didn't really understand how it got there, is not going to wash. So I think that's rather interesting. I see a thumbs up reaction from that. So there's somebody who feels quite strongly about that, which is good. Do put questions in the Q&A and the chat. Coming down to the final point there on that slide, bit of alphabet soup, but NCTDR and ICODA, they're American-based organisations, but ICODA has worldwide membership. And they've done some fantastic work on online dispute resolution standards, which I think are going to be a great assistance to anyone involved in this work. And some of their standards were adopted last year by ISO, the ISO 27001 people, which is how some of you will know it. But there are some good standards out there. And if you're involved in implementing AI, then I would recommend that you take a look at those. Look at those. Okay. Let's just move on. Just saying a little bit more about this anomalizer. There is advertised on the website a 7-day free trial at the moment, and I've given you an example there of a very simple case study on the left, mentioning some personal information about the people concerned, the professionals concerned. I noticed very cutely that the machine picked up that the dog Fido didn't have personal data, or at least Fido's data is not regarded as personal because they didn't translate that. But you can see how Tim Wallis and Mary Wallis and Fred Jones have become person 1 and person 2 and person 3. And the idea is you can put this document or a series of documents. I don't know quite how it deals with masses of documents, but certainly you can put more than one document in to this. And it's quite a sophisticated tool which you can calibrate up and down and change the settings on. It takes a little bit of getting used to. But essentially what it does is to replace the personally identifiable information with a token. I'm person 1, Mary Wallis is person 2, and so on. You can then put your document into an LLM and you use that document to ask questions and to get an output from the LLM, and you get an output which of course will not refer to Tim Wallis, it will refer to person 1. But with your output you then go back to the anomalizer and put that in, and it replaces person 1 with Tim Wallis, so the output is then read. If you're in the situation which I was in, of wanting to use AI but feeling inhibited because of the very serious professional obligations on us, this may be a way through. This is in early stages, and I can't recommend its full use in real life. All of these sites I'm suggesting are worth a look at, but you need to assess them and do due diligence before using them. So let's say something about claimant legal firms. If you're a member of the ABA, you will have, the American Bar Association, you will have received this week a quick guide to AI prompts for personal injury lawyers. That was a document which ran to some 3 pages and had a series of a series of quotes, a series of prompts, which would be of great assistance to any person, and that'll be most on this webinar, who has to analyse medical reports, whether in terms of a chronology or causation issues or gaps. Very, very interesting set of prompts. None of the prompts will contain any, I think, unusual territory as far as people on this webinar are concerned. You know all the questions, but get them all in one place and to be able to run this through. And for those of you who have used AI, which are most of you, you'll know how quickly you can get the outputs from these things. There's an area of the technology moving into what we do. Eve Legal and Even Up Law are plaintiff-based AI-powered platforms designed for running personal injury claims, particularly volume personal injury claims. I've seen them demonstrated. They suggest that it enables someone to do 3.5 times the amount of work they used to do, and that they really are very impressive. As to whether you can take them off the shelf and use them, I know not. With American technology, you've always got the GDPR data protection problem, data sovereignty, and so on, about where the server is going to be based. But certainly, if I were involved in a major claimant firm looking to the future, these are the kind of sites that I would be looking at. The claims they make are extravagant and may or may not be correct, but they're certainly of interest. Even Up Law, I think I saw a quote, yes, I have it here, has got a $2 billion valuation. And this is the reference to the big bucks going in there. Nextlevelmediation.com is the mediation site, which has a lot of decision science tools available for anyone mediating. Again, in complex claims, those tools I think can be very useful. They are a field or two away from where we're used to operating, and requires some study to get into, but this is a direction of travel. The other thing I found in my studies is that there is an asymmetry in AI adoption in the personal injury field. In the USA, the capital investment seems very much to be on the plaintiff side. That's where the money is going, and there are a large number of insurers, and it is suggested that they have not been investing at the same rate, and so there is a greater adoption, much greater adoption on the plaintiff side. Excuse me. It's always very dangerous to generalize about the United States. It's such a big place, but that theme certainly came across. When I took a look at AI adoption in England and Wales on the PI side, it was the other way around. That there are some exceptions on the claimant side, and Fletcher's is one such exception. I've seen, I think it was at the Mass conference, them demonstrate how they can feed medical records into their private software, and on a factual basis can get out of those records a chronology, which is something which many people on this call could easily do, but it would take them a long time, and it does it very quickly. But so there's also automatic intelligence used in terms of looking at prospects of success, which they use as a guide tool rather than a decision maker. So those are some of the issues that I wanted to draw to attention. I'd like to just draw breath for a moment, and Sue, have you any comments or thoughts on some of the things that I mentioned there?
And I think the point is, Tim, there is a proliferation of tools, and increasingly as the systems become more sophisticated. So there is a new idea now of vibe lawyering, where using tools like Claude, lawyers don't need to be able to code anymore to be able to create their own AI tools. So this is only going to increase in terms of the sorts of things that we are seeing. And I think certainly from a legal education perspective, sort of being able to understand a bit more about being an entrepreneur, thinking about how you might sort of move into that world, and also, from an access to justice perspective, how a litigant's going to deal with the sort of huge amount of tools that are going to be coming their way. But I think everything you're saying, especially about that idea of the way different fields are moving, is also very interesting. That certain areas of law are becoming more sophisticated than others, and different jurisdictions are also prioritizing different fields. So these are all things for us to watch.
Please, can we have any questions? I don't see any in the Q&A so far, but we'd welcome any questions you have, or indeed any experiences or issues you've had with AI. Pause a moment to see if there are any questions. But the other thing to mention, which building on what you've said, so is the use of data. I think insurers in this country, in the defence side, are very accustomed to owning large pools of data, and they become aware in the last few years, before AI emerged, of their ability to use that data for their companies, in their companies' interests. I think that's going to become of increasing importance, and certainly so far as one thing we've not touched on, and that's predictive analysis. I think that we're going to see quite a lot more of that. Let's see, we've got a question here: whether AI should not be allowed to influence arbitral decision making, from Mohammed. I've got a view of that. Any thoughts from you, Sue, on arbitral decision making? I think that might...
You go for that one, Tim.
Okay. I have seen software recently designed to assist neutrals, but in particular arbitrators, when dealing with claims. And what the designers of the software have done is to split down into discrete areas how a case is built up, the facts, the law, the arguments, and so forth. And the software analyzes the factual basis of the claim, analyzes the law, and then, rather as an arbitrator would do in person on the desk with the paper, goes through a series of steps towards the decision. But at the end of each step, the software comes to a stop and says, well, arbitrator, here's where I've got to, what do you think? And this is iterated on several occasions as the claim is built up and both sides are looked at. The software will then produce a draft judgment, a draft arbitral decision, and to say, well, I've taken into account your comments at each stage, arbitrator, and this is where I've got to. And then the arbitrator has before him or her that draft. And that is designed on the basis not of AI decision making, but AI assistance on each and every part of the task going along. And as we now become accustomed to hearing, machine learning means that each time a case is dealt with by this arbitrator, that the machine learns more and more about how they deal with it. So the software designers there would answer Mohammed's question by saying, quite right, AI should not be allowed to influence arbitral decision making. The decision maker should make the decision, but there is no harm in the arbitrator using a word processor, which is some technology to assist his or her work, and by the same token, using AI on the way through, as long as there is a human judgment there, it is argued should be acceptable. Mohammed, you may argue that is influencing, and I guess it would be, but the question is, does that matter if it is the arbitrator who makes the decision? Unless you have anything to add on that, Sue, I'm going to go on and deal with the next question of how are you as arbitrators using AI? I think that most mediators I know, sorry, getting mixed up. Most mediators I know are not using AI, but I have been starting to use the Lande RPS negotiation and mediation coach. And I had one complex case recently where I was able to feed in an anonymous scenario, and the feedback that I got was of particular help to me, and I believe to the parties. So that is going from a non-user a month or two ago to somebody who has used it and found it useful. And the more I'm learning about these tools, the more I think that yes, there may be ways of using it in the future, which is to the benefit of all concerned. So that, I think, apart from the tools I mentioned, but the Lande tool is very helpful in terms of preparing not only the mediator, but particularly the parties and any lay party, because you can actually chat to this coach and ask it questions. And so you could refer your client to this and say, we've got this mediation coming up, go and talk to the coach about anything you'd like to know. That could be a way of making sure the party is well prepared. You would want some supervision of that. So anything else from you, Sue, on how mediators are or might be using AI?
I mean, I think the point I would make, Tim, is we're at such an early stage in the use of AI at the moment. And as you said, most mediators and lawyers are still just trying to grapple with what AI is, I think. But I think the way that the future, we do need to be thinking about all of these issues. It's really going to be important. And especially in relation to topics such as ethics, and as you have mentioned already, confidentiality. I wonder whether the mediation agreement should be mentioning AI use, and thinking about how that will impact upon the way parties approach mediation, especially in an online mediation where you're not quite sure, what technology is being used. And I know in terms of confidentiality, I know you're recording this session, for example, but what if a party to a mediation records the session, and what will the implications then be if that case ends up going to court? And would that recording be be confidential at all, and secondly be usable potentially in a court case. So I think really it's about understanding, as I said right at the beginning, what AI is and its implications for the wider profession and the implications of mediation. And maybe these are issues that need to be taken up by mediation bodies themselves. And so we're addressing them, and in that way being proactive before these issues happen and cause problems, and then it needs satellite litigation. So I think that's what I would say, that we really need to get ahead of ourselves in anticipating what the issues of AI are going to be for mediators into the future.
Yeah. Thank you. So I saw a suggestion just the other day that the mediation agreement should be amended to provide for the use of AI and give cover for that. Recording is already proscribed, and in our organisation we have tailored Teams and Zoom so that the mediator can't record accidentally. We disable that button because that's an important aspect.
But yes, the parties might, I suppose.
But indeed, the parties could, yes, despite their duty not to, because of.
And that might affect privilege in into the future. So there are some of these issues that are sort of being teased through the courts already, maybe not in relation to mediation, but that will affect mediation. So having bodies that are actually actively discussing this, I think, are going to be really important into the future. Yeah.
Mohammed asks another question. Sorry, Jen Harris was the person who asked the last question. Mohammed asked another question, which I can't answer. Maybe you can help. So how far AI Act 2024 has improved mediation? I'm not aware of the detailed provisions of that act, and I've not heard of that it's been being suggested that act has impinged on mediation in any way. Do you have any?
Well, I mean, I suppose the only thing I would say, because it's a very broad-based act, and so in terms of the detail, I don't think it's impinged upon mediation, not something that I'm aware of. But I do think that Article 14 of the Act, which is something that the Master of the Rolls alluded to in his speech last week, which does say that high-risk AI systems must be designed and developed to ensure effective human oversight during their operation, is something that will apply to systems that are devised within the courts using mediation. So I think it's going to be very difficult to use AI systems in the court without thinking about the provisions of the EU AI Act, which is going to restrict that sort of high risk system. But I think that's really sort of where we're at. And as I say, once again, this is early days, and the EU AI Act is open to quite a lot of interpretation at this stage.
Thank you for coming to my rescue on that, Sue. And I think that answers Mohammed's other question. Shouldn't AI be explainable for making any award, as in mediation? I think the answer is, if AI has been used, then it should be explainable. And one of the principles is that there should be the ability to find out how AI got to the place that it did. Moving on to a question from Visesh. With the current unsustainability issue of AI, is there any regulations in place legal entities adhere to with respects to ESG principles? So it's implicit there that there's a suggestion there is a unsustainability issue of AI, but I'm not aware of any regulations in relation to ESG principles, so I can't help you on that, I don't think, session, unless you can help, Sue.
I think the creation of data centers to handle the use of AI, and especially as we move into sort of quantum computing, and there's more reliability on data centers, for example, that ESG principles become more important. But we have to bear in mind that these questions are also political, and that in the UK, the government is very keen to encourage the development of innovation and AI systems, and for them to be linked to the UK. And so in terms of regulation, there just isn't at the moment the development of that sort of regulation anyway, which is something, as I suppose I'm alluding to, that companies themselves do need to think about these ideas, and that, as a whole, as a legal community, we need to think about some of these implications. And I do think, raising the ESG principles is a really useful discussion, and these are things that we need to keep talking about.
Indeed, and that does remind me of a conversation I had recently with a developer who was saying, because their LLM was on a very closed basis, with a very restricted amount of information. The amount of energy required to process that was vastly smaller than putting into a machine which had got basically the world's knowledge in. And he was suggesting that was an important issue regarding sustainability. So, Vistesh, your question, I think, is acknowledged, and that there is an issue there, as Sue has said. Mary Jane asks a question here, which touches on a conversation I had with a fellow mediator recently. How quickly is AI able to create a draft of a legal document? Is utilising AI to assist in document preparation, saving arbitrators time and money? Well, I think, speaking generally, for looking at some documents that I've seen prepared, the speed is quite jaw-dropping. It depends how many iterations you have and how complex the task is, and whether you have to go back several times. But I've seen simple tasks given to an AI tool. I'm getting another thumbs up for that. A very simple request, and the document is produced in seconds. Where even the brightest, best, most knowledgeable lawyer in that area would have taken 10 or 20 or 30 minutes or more. But certainly a 10-page document, bang, is there, compliant when checked over. And I was asked, this is a conversation I had a fellow mediator on a mediator reflection discussion, said, Tim, if you've used AI for your mediation, shouldn't you be reducing your fee because you spent less time? And I said, well, there could be an argument for that, particularly if you'd given an estimate of fees based on reviewing a huge number of documents, which you've used AI to save time. So that, on the other hand, sometimes when you're using the AI coach, it throws up questions you haven't thought of, and you're giving greater, deeper, more lengthy reflection to a matter and getting a better result. And my tongue-in-cheek riposte was, on occasion like that, I might say that AI has augmented and enhanced my output, and I might want to increase my fee. I wasn't being serious, but I'm just making the point that those things can cut both ways. Some very interesting questions arising out of that. So,
is this not an argument for lawyers and mediators becoming far more familiar with AI and how it works, in order to be able to deal with those questions? I think there was a Channel 4 documentary a few months ago where Garfield AI, which is the software I've already mentioned, which devises forms and documents for use in small claims court for £2 each and can do them automatically, was pitted against a junior lawyer who was preparing the papers and cost something like about £1,000. And the question was asked about, why would you use the lawyer when you could use Garfield? And exactly as you're saying, I think lawyers and mediators need to become far more adept at understanding AI and seeing where the gaps are and what they can do, and sort of marketing themselves to move into this space, which goes back to what the Master of the Rolls was saying, that the lawyers will continue, mediators will continue, but it's what we need to do in order to make sure that we have a really good quality offering to people, and that requires an understanding of AI.
Yeah, indeed. Right. I certainly support. I support that, and I think in terms of the economics of the law firm business model, this will be challenging, and those wedded to the billable hour, as the Americans call it, may have some concern. I see we're coming towards the end, but the question here was for you. So, do you remember the name of that documentary, please? So that's
I'm just looking it up, and I'll just try and put it into the chat whilst you're concluding.
Okay. Well, to conclude, I would like to thank you for your attention today and supporting the webinar. It is somewhat unusual compared to the usual trust mediation webinars, but it is also aimed at letting you know that at Trust Mediation we are certainly looking at these areas and seeing what developments we can make use of to assist you. Just to remind you, also, who's looking at that, we've got the next Trust Mediation webinars coming up 20th May at 1 o'clock and 24th of June. We're not quite certain of the subject of the 20th May yet, but we shall be saying something about the new person intermediators that we are on the cusp of appointing. And so, thank you. I see you put the documentary in the chat. that brings us to a close. Just to remind you, if you're at a firm dealing with personal injury or clinical negligence work, you can appoint an ADR champion. We'll be very happy to work with you and your firm on that. But please don't hesitate to get in touch with Trust Mediation if you're interested in our ADR champion scheme, as ADR, an online dispute resolution, and AI continues to advance. And that brings us to 2 o'clock. Thank you so very much indeed. Really good of you to join me, and I've enjoyed our discussions, and certainly being rescued by you on some of the questions that I couldn't answer. Thanks everyone for coming along, and hope to see you next time. Bye-bye. So we can stay on the line. There's some very nice comments in the chat. So there's still 1 or 2 people on the line. They may have walked away from their machines, but so we may be in company of others. But just to say personally, thank you very much indeed. I really enjoyed that combination, albeit at short notice. And maybe there's a paper in this for us for something that I would be interested to talk to you about that, because we certainly have come at this from different angles, and that would be interesting to explore. I'm told I shouldn't suggest things like that because I'm behind with other work, but I think this is such a fascinating area, and I think it enables, certainly looking at my work with clinical negligence and personal injury practitioners, some of them are way in front of me on this, but a lot of them haven't got time to deal with it.
What about the CMC conference? I've just signed up for that today. Do you think we could do something there?
Yeah, that would be good. Yeah,
because I think that I don't know who is going to talk about it, but I don't know there's anybody who's really sort of thinking about this in that way, or even just rehearsing some of the things that we've done today, and then using that as the basis. Because where we'll be in October, who knows? But it would be good.
That's the trouble. I had a file of information for this webinar when I started thinking about it about 10 days ago, but half of the information that has come in since then. It's coming in 2 or 3 times a day. Stuff that you think I must put that in the folder. That's relevant to this area. It's getting a bit silly. Yes, I'll have a look at the date of that. And would you like to make a suggestion to them? See if they'd.
I'm not quite sure who's organising it. Are you anything to do with the CMC? Because I saw. Are you not some sort of CMC champion?
Yeah, I'm registered with them, so I can suggest. Yeah. Okay.
Yeah, I mean, if I could have a look, I'd probably see somebody at the AGR conference, but I'm not sure who organises the conference. Maybe Victoria Harris might. Yeah, I could. I mean, I'm happy to say something as well, but it's probably good if we both did it.
Please do. Well, let's both make put some feelers out and see if we get a new response.
You've probably got more sway with them as a mediator than I have, but
okay. Well, I'm one of their senior mediators. I think I'm not quite sure they call me, but yeah, I will. I'll put a request in.
It's worth asking, isn't it? And as you say, that might be a good sort of basis then for springing a paper from at the end of that. I really appreciate the opportunity, Tim. I'm actually starting a course with Oxford next Monday on AI and on AI, and it's sort of with doing the computer sciencey bit, but they were also going to be addressing the EU AI Act. So I thought, well, that at least it's given me a bit of a basis, but I think I'll know more hopefully after I've done this course.
Yeah, and more will have happened between now and then. This is moving so quickly.
Absolutely. No, definitely.
Yeah. Great. Okay, let's keep in touch, and thanks once again. I really appreciate it.
No, thanks for the opportunity. It's brilliant. Lovely to work with you.
Great, isn't it?
Again.
Great. Bye-bye.
Take care. See ya. Bye.